Good afternoon, everyone. Welcome to Thompson Coburn's legal webinar on the Changes Clause, the ABCs of REAs. We thank you for joining us today. My name is Jeff Newman. I'm here with my colleague, Jana Russ. But before we begin, we wanted to cover a few housekeeping items. Certainly, if you have any questions during the webinar, you can submit them through the Q&A widget at the bottom of your screen. We will try to answer these questions during the webcast, most likely toward the end. But if a fuller or more detailed answer is required, or we simply run out of time, it will be answered later via email. A copy of today's slide deck is also available in the resource widget. We encourage you to download any resources or links that you may find useful. You can find additional answers to some common technical issues located in the help widget at the bottom of your screen as well, if you are having any technical difficulties. This webinar is a CLE accredited program in Missouri for 1.2 hours of general CLE credit, and in California and Illinois for 1 single hour of general CLE credit. We award CLE credit based on attendance for the entire 60 minutes. From time to time, you will be required to click a pop-up screen to reflect your continued engagement in this program. We certainly value your opinions and appreciate your participation in the course. There will be a survey afterwards. We would appreciate you filling that out and letting us know if there's any other specific topics you would like Thompson Coburn to present a webinar on. And once again, we look forward to speaking with you and engaging with you this afternoon. With that, let's begin. I think what we'd like to do today is discuss several key factors or points relating to the Changes Clause. We certainly won't be able to cover everything. Jana and I certainly would be able to spend a day or more on this topic alone, as we've done in the past. But what we'd like to do, as I mentioned today, is to really synthesize the key points down to give you a flavor of how to deal with the Changes Clause and how to best mitigate your risk as a contractor or as a government employee and maximize the return on your contract performance. As an aside, as you will see, these letters on the screen are really used as mile markers or a roadmap for our program today. Please do not spend time trying to figure out if there's a magic clue or secret word built into the program because they're not. As I said, they're really just guidelines for moving forward. So if we begin on the Changes Clause, changes, as you probably are well aware, are one of the most distinctive features of government contracts. They're generally not seen in the commercial marketplace for the purchase of supplies and services, and by that I mean one party generally does not have the ability to make a unilateral change for the acquisition of supplies and services. Generally, you have to have a bilateral or mutual commitment to change a contract. Changes Clause in U.S. government contracts covers actual changes under the contract. It is not to be confused with a breach of contract claim. Changes are permissible, and there are a host of Changes Clause in the FAR, as we will shortly see. But what I'd like to spend a little time on with respect to this slide is the issue of constructive changes. And by that I mean a constructive change is sometimes called a change by implication and occurs when the government, by its actions or inaction, changes the contract without specifically adhering to the requirements of the Changes Clause. So some people call it a change by implication, other people call it an informal change, what have you. But the courts and the cases have defined a constructive change as an oral or written act or omission by the contracting officer or otherwise authorized government official, which is of such a nature that it has the same effect as a formal written change order under the contract. So what does that really mean in a practical sense? And that is, for example, erroneous interpretations of government regulations by the government contracting officer may constitute in and of itself a constructive change. They're very fact specific, but we need to look at these on a case-by-case basis. And in government contract law, these constructive changes also are recognized and well established, as is the changes clause. If you want to read more about this, because we're not going to have an hour or two to spend on this very issue like we might normally otherwise do if we had a full day session, we would recommend you look at the language at FAR 43.104 and the notification of changes clause at 52.243-7, which both recognize the concept, which is governments allow for changes, but they're not equate to a breach of contract. Brief history. I don't want to spend a whole lot of time on this slide, although Jada was around when they first passed the first changes clause in 1818. These are the changes clauses that we've talked about in the FAR. The construction clause, you'll see the citation on the screen, the cost reimbursement services, and the like. I do want to spend one moment, and we'll talk about this in more detail later, but on the commercial items clause, which is 52.212-4C, if you want a specific citation, is the changes clause under the commercial item terms and conditions. This deserves a special mention, at least for now, and as I said, we'll talk about it more later. But as you will see, under this clause, unlike any other one that you will see in the FAR or any other agency supplement, this clause requires a bilateral change. In other words, both parties have to agree on the change when you're dealing with a commercial item as defined under FAR Part 2.101 or required under FAR Part 12. And I think that's an important distinction to keep in mind for those of you who are attending this webinar who provide commercial items to the government, or if you're a government contracting officer or otherwise purchasing or acquisition official. When we deal with changes on the commercial items, you do need a bilateral change.
And just so you guys know, I had just started practicing law back in 1818.
Let's take a look at one of the clauses and break it down a bit. And I really don't care which one we would normally look at, but fixed price is probably the place to start, since it's the first one in the FAR at 5243-1, and it sort of flows nicely for purposes of this discussion. Let's sort of look at this sort of section by section. The first thing to note is the contracting officer is the only authority to make a change to the contract. It's not the program manager. It's not the contracting officer's technical rep or COTAR. It's not an engineering personnel. It's not program or contracts people. It's the contracting officer. He or she has the warrant authority to make a change to the contract, and that's the only person authorized to make a contract. Oftentimes you'll see in your contracts or subcontracts that it specifically says the contracting officer or the contract person at the prime contractor is the only person eligible to make a change. No other official is authorized to make a change. It's important to keep an eye on who the authorized officials are to make that change. As we said before, that authorized official, the contracting officer, she can change the contract unilaterally, again, unless it's a commercial item contract where you need a bilateral change. And what does a change do? What can a contracting officer change or a prime contractor change to a sub who's flowing down the terms and conditions? Well, as you see on the drawing 1, 2, and 3, the drawings, designs, or specifications can be changed. The way the supply is packaged or shipped, the place of delivery, the place of performance of services. There's a whole host of performance factors that can be changed by the contracting officer or the higher tier contractor. And if that occurs, the contractor is entitled, and this is subparagraph B, is entitled to compensation through what we call an equitable adjustment. And an equitable adjustment is sort of the supporting information that is submitted to the government that establishes the increase or decrease in the cost or time of performance, and the contractor is eligible to reimburse for that. We're going to talk at length about the equitable adjustment process in a little bit. But let me just say a couple things about the request for equitable adjustment now, and Jana will cover, I think, a good portion of this later as well. And that is, you should, as a contractor, take deliberate action and your time putting together a good request for equitable adjustment, because the cost of doing so allow a contractor to allow those costs to be allowable for the contractor. The cost of putting together and compiling your equitable request for equitable adjustment are allowable under the FAR, under the cost principles. The costs of putting together a claim are not. So what we generally advise clients is, if possible, spend time putting together an equitable adjustment. Those costs are allowable. And if unable to be resolved through negotiations with the contracting officer and the government, you then just convert that equitable adjustment to a claim at fairly minimal cost and move forward with the litigation of the claim and resolution of that dispute. As I said, we'll talk further later about equitable adjustments. But please note in the clause, as you can see in subparagraph C, and we sort of highlighted this language for your attention, is that the contractor must assert its right to an adjustment under the clause within 30 days. So there are specific timing obligations that often follow with respect to making sure the change is properly brought to the government's or higher tier contractors' attention. Often, if the request for equitable adjustment is filed or submitted and it's not able to be resolved, as I mentioned before, we then sort of move into the more formalized claim process, and that becomes, once again, in part subject to the disputes clause of the contract. Similarly speaking, if you fail to agree on the amount owed or the time extension, in other words, the request for the equitable adjustment is denied, or the parties cannot agree on the amount of costs incurred for the increase of performance or the time that should be extended, then you become subject to the disputes clause of the contract, and that's in subparagraph E. Please note that although this course or this webinar today is really not going to get into the disputes clause in a whole, to a large extent, one thing you may want to consider is if you are going to be subject to a dispute under the disputes clause, you should have a proper remedy. And what do I mean by that? But what I mean is, if you're unable to agree on the request for equitable adjustment, the disputes clause in the governing law should be something reasonable. We'll talk about the use of alternative dispute resolution later on, but, we've seen agreements before from a small business where the resolution of the dispute would be in the International Court of Justice in Paris. And now Paris is lovely in the springtime, but if you're a small business, it'd probably be pretty difficult to get to Paris and pretty, unaffordable with respect to resolving your claim. So have a reasonable disputes clause that addresses where these disputes will be resolved. So what is the purpose of the change clause? Essentially, why do we have this clause? Well, historically, as many of you may be aware, generally the government and the government contracts between the contractor and the government are not perfect when awarded. During performance, many changes may be required in order to fix or correct inaccurate and defective specifications, react to newly encountered circumstances, or modify the work to ensure that the contract meets the government's requirements. And in order to avoid having to recompete each and every contract where this set of circumstances or one of these circumstances may occur, we have something called a changes clause. But any changes made to a government contract that may force the contractor to perform more work or to perform them in a more costly or elongated fashion from a timing perspective may require additional funding. And so what happens at that point is you then, as we mentioned before, look to an equitable adjustment of the contract. But unfortunately, there are times, and it's often the case, when the parties don't always agree on the scope, the value, or even the existence of the contract change. And the last part is worth noting. Sometimes one party thinks there's been a change and the other party does not. So there can be questions about the existence of a change. And we can say, based on the practice that Jana and I have, contract changes often account for a significant portion of the litigation in the government contracts context, especially on initially when we started practicing on construction contracts, but that's a natural. But we've been seeing more and more litigation and controversies with respect to the provision of supplies and services because of the question of whether there was change, and if there was, how do you evaluate that change? This next slide is really a summary of much of what we've been discussing. We want to make sure that the changes only cover changes within the scope of a contract. We can't have changes that are outside the scope. There's a timeliness requirement of 30 days. We want to get either increased funds or additional time for a contractor to perform the work based on the change. And we wanted to educate the contracting officer on what needs to be done with respect to the increased costs of performance or timeliness of performing the work that's set forth under the contract. But on this slide, we're also introducing a new concept that some of you may be familiar with, some of you may not. It's called kernel change. And a kernel change is really sort of the antithesis of what the changes clause is about. And it's really an out of scope, or as I said, a cardinal change to the contract. It's a change that's not within the general scope of the original contract, either in terms of the type of work or the amount of work, period of performance, manner of performance, what have you. It really is sort of, if you're providing a widget to the government, this is something that increases a whole other type of deliverable under the contract. And the result is if the court or armed services or any board of contract appeals finds a contract modification to be outside the scope of the contract, in other words, a cardinal change, the contractor is not required to perform the work because that's not what the parties bargained for. It's not part of the contract. And if the government or if there's been a change to the contract, that contractor may be entitled to breach damages for a breach of contract. Now, what's interesting, and I don't want to get too far ahead of ourselves, but I think it's worth mentioning, is that if the contractor performs the out-of-scope work, in other words, performs the requested work, which is in fact a cardinal change, and a court, if you will, or the case law will support this, finds that the contractor performed the work, the contractor's only remedy is an equitable adjustment. You can't then go back and say, I want my breach damages as well. It's only when the contractor does not perform the work is it eligible for breach of contract damages. We'll talk about that with a little more clarity later on. But if you have any questions, please put a question in through the widget. Before I turn the next set of slides over to Jana, I think it's worth noting how this process works. And we've touched upon this, already. But if the government and contractor sort of have identified that a change occurred, or perhaps maybe just the contractor discussed the need for a change because of somewhat it believes is an increase in the cost of performance, it will contact the government and begin the process. And what is that process? Well, generally, after initial discussions, the government will ask for a request for equitable adjustment, where the contractor provides the support and the information that it believes justifies a increase in payment under the contract or a time extension, what have you. The government will look at that REA. Often the case, it will begin negotiations with the contractor or ask DCAA, if it's a Department of Defense contract, to audit the contract, perhaps the rates, perhaps an agency has a grant and there's a change under the grant, and it's a similar changes clause is in the grant that we find in the FAR under the Uniform Grant Guidance, and that agency will go ahead and sometimes have an independent audit to make sure that either the rates are justifiable, the increased work was supported by the information. so on and so forth. So the government just doesn't take the request for equitable adjustment and say yay or nay. It will sort of review it and also oftentimes begin either formalized or informalized audit. The goal is to reach an agreement. If it is, great. A contract modification usually follows, and often with the standard release language at the far reference up on your screen. We would suggest if you are engaging in discussions with the government, you preview FAR 43204-C. So this is not unfamiliar to you when you get the documents back. And then if you have any questions, you should consult your company's legal counsel or contracts folks to make sure that you fully understand the scope and extent of any release that is ordered under the contract.
All right. So Jeff has talked about the more hunky-dory side of things in a formal change situation, but as he referenced, there are instances when sometimes the contractor and the federal government can't agree on what the contents of an equitable adjustment would look like to a contract. And in that situation, the government's not going to just keep negotiating with the contractor indefinitely. What they'll do usually is issue a unilateral change order, and that requires it changes the contract to include whatever the government wants as far as the performance side of things, and then the contractor can continue trying to resolve the issue, but at that point it becomes a dispute. And Jeff mentioned that a little bit earlier, but the dispute is going to be governed by the disputes clause of the contract, which has a duty to proceed in it. And that is a requirement that the contractor continue performing while the contractor and the government iron out the issues. So that's really what happens if they can't agree on the formal change side of the process. And Jeff mentioned something earlier, which is the commercial items changes clause, and we bring it up again to point out that under the commercial item changes clause, as Jeff mentioned, there is not a unilateral change order allowed by the federal government. It does require that any changes to the contract are bilateral and that the parties agree to it. However, just because the contract doesn't say that there is a unilateral change right for the government does not mean that the government sometimes does not try to use that power. We have seen the government issue unilateral change orders under the commercial items clause, and what happens then is the contractor still has what's known as a constructive change, which we'll go into further detail on in a bit, due to the government's action, and we'll talk more about those constructive changes now.
And if I could say one thing, Jana, and that is, and once again, really a little bit outside the scope of this course, but I think it's valuable to understand. To Jana's point, it's really important when you are looking at your contracts to make sure you have the right clauses in the contract. If you are a commercial item contractor, this clause is the one that should be in the contract to govern changes. You shouldn't have this clause, 52.212-4, and then also the standard changes clause that applies to you, because if you're providing a commercial item, this is the clause that should drive the process, not the standard 52.243-clause whatever clause, depending on the type of contract that's involved in the performance.
Yep. Exactly. So it's important that contractors understand the ramifications of each type of change clause. And part of why that's important is this concept of constructive changes, which does apply to, like we said, the commercial items changes clause, but it's much more developed under the other clauses that were on the previous slide near the beginning. And this is a concept that Jeff previewed, which it's really, though, a concept that came about pre-1978. And for some of you government contracts history buffs on here, you probably realize that that is the year that the Contract Disputes Act was passed. And this is a theory that the boards of contract appeals came up with because they couldn't have jurisdiction over breach of contract claims or implied contract theory claims, so they created what they called a constructive change. And the idea is that the contract is changed, but the procedures under the changes clause haven't been followed. So those formal change procedures have not been followed. So a change has constructively occurred. And because of that, that's why the contractor still has access to an equitable adjustment and why they would request an equitable adjustment, because there has been a change to the contract under the changes clause. And so that history is important because it helps, I think, folks now understand that a lot of the things that we're going to describe as constructive changes, you might think of in the commercial context as breach of contract claims. And they probably would have been if not for this theory that was developed before 1978, which still is very much alive and kicking. And the reason we'll talk about later, Jeff talked about earlier, so part of why the government likes the concept of constructive changes. So that's why it continues to be alive and kicking. So now that we've talked a little bit about what constructive changes are generally, this slide has a list of a few common types of constructive changes. These are not the only types that exist, but these are some of the common ones that are often litigated. And I'll just briefly go through and describe some of these that maybe require a little bit more discussion. So really, delay and disruption is whenever the government has directed that the contractor do something, or when there's been some kind of an excusable delay and the government isn't recognizing it. It's tied very closely to the idea of acceleration. And so acceleration is, of course, if the government requires you to speed up work, but that might also occur, for instance, when there's been an excusable delay on a contract and the government is still requiring the contractor to complete the project on time. So that's the idea of acceleration. Overzealous inspection is the idea that the inspection can't unduly interfere with contractor performance, and it also needs to be the type of inspection that the parties believed they were going to have when they entered into the contract. So, for instance, the government can't decide to inspect the facilities in a certain way in a contract in a different way than they have for the prior 18 years. The next, I think, is pretty self-explanatory, demanding work beyond the statement of work. This could be a one-time demand, though, or it could be something that we sometimes refer to as scope creep, where the government is making these small demands and it becomes work beyond the statement of work over a period of time. A couple of other types of common constructive changes are defective specifications and superior knowledge. And I mentioned those two together because really they deal with the fact that the government did something wrong probably around the time of contract award. So defective specifications are going to be times when the government provided the contractor specifications for performance, but they had some kind of issue and they were defective. And superior knowledge is also something that happens at time of award because it's an instance where the government may have access to information that they don't disclose to the contractor, or where they disclose incorrect information, and that withholding of information or withholding of correct information causes the contractor to incur additional costs or to have to increase the amount of time to perform. And finally, I think one of the more common instances of constructive changes are contract interpretation issues, and that's when the government puts forth their interpretation that requires more or different work than what the contractor believes, and that work is also, or it could be work that is at a higher standard.
And that's my personal favorite. Because, and as Jada said, we see a lot of that. A lot of the ones leading up to contract interpretation, the specific case law on, each one of these topics. The contract interpretation is sort of an interesting one because it often depends on, as I mentioned before, the particular facts and circumstances of the particular interpretation we're dealing with. But we do see a lot of that because the government says we want you to do X, Y, and Z, and we say, well, we agree on X and Y. The contract includes that, but there's no Z, and then you have a 6-month fight about or dispute about whether Z is covered and should you do Z or not do Z. So that's what the constructive change and the contract interpretation looks like.
And so just to see what kind of experiences the folks attending have had, we wanted to ask you guys a question about what types of constructive changes have you all experienced previously. And these may be things that they could be big, they could be small, but just to give you guys a chance to think through some of the issues you've had in the past on some of your prior projects, whether they be whether you're on the government side or the contractor side, but just wanted to give you guys a second to think about what are some of the common things that you've seen, and also let you guys have a quick look at what your other attendees may have experienced.
And you can check more than one box.
We'll give you guys just a couple more seconds to let us know what kinds of constructive changes you may have experienced. All right, so it looks like folks have experienced more often the delay in disruption, acceleration, defective specifications, and superior knowledge. Which it's interesting that both sets, there seems to be kind of two sets, I guess, is a better way to describe it. As I mentioned, delay and disruption and acceleration are often tied together, and defective specifications and superior knowledge are often tied together. So thank you guys for participating in that quick poll. And I just have a couple more things to mention before handing the reins back over to Jeff. As mentioned before, constructive changes are generally breaches in the commercial world. However, just because the government and the boards of contract appeals often deal with these kind of issues through the constructive change process or theory, that does not mean that breaches do not exist in government contracts. Breaches definitely do still exist in government contracts. That said, the government really does not like to deal with issues under the breach theory. The biggest reason is because they can limit recovery for the contractor under the constructive change theory, and because it's handled under the disputes process, the constructive change theory also includes that duty to proceed that we talked about earlier. So once we've gone through kind of the idea of understanding that there's potentially a constructive change to the contract, oftentimes that's when contractors start to think about the harms that they're suffering because of those constructive changes and whether or not there's anything they can do about it. And some of those harms are things that are available as adjustments under the contract as an equitable adjustment. And this slide has a list of a few of the things that we've seen provided by the government as equitable adjustments to the contract when there's been a change. Generally, these are things that cover money or time. Most of the time, contractors, if they're going through the process for a request for equitable adjustment, want to get additional money, so increased costs of performance, delay or standby costs, unrecovered overhead, profit, interest, that kind of thing. However, there are instances when contractors definitely need more time. Or, once again, because time can be tied to other things, there may be a couple of points made in the same request for equitable adjustment, some for time, some for money. And for those folks who are trying to think of why time might be important on its own, getting additional time will help prevent adverse government action, such as a termination or oftentimes more importantly, for preventative purposes, for past performance ratings. So if a contractor keeps fighting with the government over whether or not something was due at a certain date and they can't come to an understanding on it, the possibility of having a poor past performance rating can push some contractors to requesting an equitable adjustment. And I think that's all for me for right now.
Yeah, and unlike the Rolling Stones would say, time is not always on your side. We really do not want to be in a situation where the items that Jane had just talked about, we're sort of discovering too late in the game. Recognizing those changes to the contractor, critical to preserving, a contractor's rights and maximizing any potential return relating to that particular change. On the slide in front of you now, we've highlighted some of the difficulties in recognizing these changes. There's contractor simply realizes the problem after the fact, and those 30 days have come and gone. The money has already been lost, so on and so forth. So how do we prevent, one of two things from occurring? One, that a contractor is unable to realize the existence of an actual or constructive change, as Jane had just sort of talked about. Or number two, how to avoid sitting on your hands as a contractor and taking the necessary steps to identify the change and then pursue the appropriate steps to fix that. So what I would suggest is, as we look at the next slide here, the preferred approach is certainly to be proactive, not reactive. And what do we mean by that? In terms of training, training is really the key. Recognizing the elements of a change at the program, at the contract, the program, and sometimes even the engineering level will get you a long way in identifying the issues that could potentially underlie an actual, which is fairly easier to do than the more complex constructive change. When you have identified a potential change, and even if you're not sure it's a potential change, it's often not a bad idea to set up some new job numbers or accounts where those costs of performance could flow. In other words, segregate your costs. If you think there's an issue, do that, and that will help you immeasurably in the future. Go back in and capture those costs that were performed on the work that you may have thought is an actual or constructive change. Certainly make sure that your claim or even before that, your REA is timely filed. Pay attention to all the timeliness requirements. We just touched upon the 30 days here, but if you go down the road through negotiating with the government and then through the claim process, there's even more timeliness requirements that you need to make sure you comply with and understand. So make sure you have that in front of you as well. And make this an urgent priority and have what we would suggest to have a preordained system or a system set up to handle these changes. So whether it's, consulting with people, legal or contract people within the company, the accounting people to manage those separate accounts is critical to performance. You also want to make sure that when you learn of a change, you talk to the witnesses and gather the evidence that's generally available as quickly as possible while it's fresh in everyone's mind. We had a situation not too long ago where there was a change, or we thought there was a change, and the company didn't come to us for 6 months, and they were simply out of time, not only in terms of filing the potential request for equitable adjustment, but more importantly, when we went back and at least initially talked to the people who were supposedly involved, they had no meaningful or substantive recollection of what happened. So it's important to go back in and make sure you grab those individuals, not physically, of course, but you talk to those folks and try to capture as much of the supporting documentation as probable. The use of alternative dispute resolution is encouraged to resolve these matters. I don't want to say a dispute because it's not a dispute yet, but you submit your request for equitable adjustment or even before then, you may want to convene a panel of the senior executives of the company. Sometimes when you remove it from the people who are on the front lines, whether it's an engineer, whether it's a contract person or a program person, and have the senior executives, say senior vice presidents and above, as an example. We've done that before with great success. Those people have incentives to get a resolution to the matter done quickly, because not only does it cost both companies money to be involved in a protracted dispute or litigation, but more importantly, it's pulling people from their areas of specialty, whether it's a business development role, whether it's a performance role, from what they do best, which once again generally will generate revenue for the company. So the use of ADR, and there's all different types of alternative dispute resolution that are out there, is very helpful. And then certainly last but not least, on your agreements. We've talked a little bit today about subcontracts and subcontractors and how they fit into this process. And by that, we generally mean that the changes clause usually flows down from the prime. Once again, as we mentioned earlier, make sure you flow the right clause down, prime contractors. And subs, please don't argue about the need to have a changes clause in your agreement. You have to have one. You could negotiate to make sure you have the right one, as we mentioned before. But also, if you want to address any particular issues that are related to the specific performance of the contract, go ahead and do that. But just be aware that the prime has to flow some sort of changes clause down to you, and both parties should be able to negotiate that without much fanfare, and that really affects all levels of the contracting process.
And before Jeff goes on to the next slide, I just wanted to add in about the subcontractor agreements. One of the things, for instance, that a prime may want to consider is that 30-day notice that it has to provide to the government. So you don't want your subcontractor to give you notice with 30 days, because then you don't have any time to review it before you try to work with the government on the issue. You want to make sure you have enough time to review the subcontractor's alleged change. So those are just that's just one of the considerations to think about. But there's a number of things that you want to think about as far as what kind of information do you want from your subcontractors, and and whether or not you're going to be required to push forward on a change that you don't agree with. And so those are just a couple of the things that you want to think through in your subcontract agreement.
And Jana raises a great point, and I should mention we've done these panels with these presentations with other folks. Professor Nash, for those of you who know, is the guru of government contracting. He's made a very useful suggestion some time ago, worth repeating. With the 30-day notice period, doesn't mean you have to wait 30 days. He's of the opinion that as soon as you think there's a change, just send it to the contracting officer, and then you're covered. And you've sort of met your burden and obligation. And so something to consider in addition to what Jana said, which she's spot on there. In the prime and sub, the subs really have to make sure that they accommodate the prime's obligations under the contract, and the subs want to make sure that they have ample time to get their potential request for equitable adjustment in the contract. Next slide is really sort of more of a nuts and bolts type set of suggestions in order to prepare for the REA, the request for equitable adjustment, and perhaps even potentially a claim down the road. Contractors need to compile, all the key information. First, you want to gather and review all the documents as indicated on the slide. Get the emails, the correspondence, interview employees and other personnel, as we discussed earlier, preferably contemporaneously to the particular event. You want to preserve the product of each interview, whether it's on video, whether you get a statement, whether someone's taking notes of that, and really, all of this information will serve as the foundation of any legal and business review. And I say business review because we all sort of as lawyers, we want to make sure that you're legally covered, but a lot of these issues will generally go to some strategic business decisions that the company can make. But all of this information will really serve, as I said, the foundation of any legal and business review of the company as it makes with regard to these changes issues. Jada will talk shortly about all of these legal underpinnings, but I want to talk about two additional items that are on the slide. FOIA, the Freedom of Information Act. I know probably many of you are familiar with the FOIA process. As most of you know, it's not something that happens in any timely manner, but contractors should consider a FOIA request if the agency has information that it believes that the contractor believes could be helpful in formulating its a request for equitable adjustment. The problem is getting that information within 30 days. Although some of that information may be able to be used in a claim process, agency websites have guidance as how to submit a FOIA request. And when I said 30 days, it's the notice provision. You still have time to prepare your REA, as I said, so you may have some more time to get that information from the government agencies as you prepare your REA. But more importantly, the last bullet is one that I want to focus on, and that is discussing some recommended techniques for preserving the evidence. I think the one we'd like to focus on today is the litigation hold letter. If any of you have been involved in litigation before, sometimes you at the company will receive a litigation hold letter saying, such and such matter is under investigation. Please preserve all records. Do not destroy any information, and the like. Well, that's a perfectly viable approach. We have extended that to sending that litigation hold letter to the government agency officials involved in the particular work that's being questioned as whether or not there was a change that occurred. It certainly shows the seriousness of the contractor in trying to negotiate a resolution, and I will confess it's often a bit startling to our government contracting officers, counterparts that we work with, but I think it's necessary because we want to make sure that the government's on notice that all of the information that they possess may be discoverable or valuable in helping us put together the request for equitable adjustment and potentially a claim down the road. And we want to make sure that evidence is preserved. We think this is very effective, and there's nothing wrong with doing it if it's worded correctly. So we would encourage you to consider that litigation hold letter with respect to one of the strategies as you put together your request for equitable adjustment and claim.
And on the flip side of that, I think it's just as equally important for folks on the contractor side to make sure all of their team understands that they need to be doing a similar preservation, because if you're going to require the government to do that, you need to make sure that the government, if they ever ask for documents from you, has equal access. And one of the things also I wanted to point out, as you're going through that investigation and collecting documents, you're not just doing that with the idea of litigation in mind. I think it's really you're doing it to protect yourself if you are going to end up in litigation. But in reality, during that time period, hopefully your program folks and executive level folks are talking with the government and trying to resolve it just through discussions or potentially through questions and emails. That's typically what we see happening. But at that same time, you're wanting to develop your position for the potential of submitting a full request for equitable adjustment or REA, or potentially litigation down the line. And with that in mind, what you're going to be doing after you gather all of that information, or even as you're gathering it, you'll start analyzing things from the legal side. And you'll want to make sure you take a look at some of the case law or the case law from the Court of Federal Claims and the applicable Board of Contract Appeals. It's going to be hard for some folks, especially who've been dealing more on the commercial side of things, to get away from thinking under the breach analysis. but the case law under each of those types of constructive changes we talked about earlier has developed under each theory, and you'll want to make sure you have a good idea of what is required to prove each type of theory, as well as the type of remedy that's available for the different theories. And so those are some of the kinds of conversations folks will be having internally on the contractor side, or should be having internally. And you'll also want to make sure that you talk through then, after looking at that case law, what types of facts you might need to prevail or convince the government that you need an equitable adjustment based on that type of theory. And you'll really just keep going through some of that and developing your ideas so that you can include those in your request for equitable adjustment or the claim. So once you've gone through and determined that you have some viable change theories that should be compensable or should be remedied under the equitable adjustment theory, that's when you, I think, really have to sit down on the business side, as Jeff was mentioning, to talk through whether or not to submit an REA or claim. There is, of course, the legal analysis of whether or not a change exists and what type of remedy you could get, but is an REA or claim something you want to submit? And ultimately, it is a business decision. You'll want to discuss the potential impact it could have on your relationship with your government customer. And part of that analysis is probably going to take into consideration what you'll have to prove under that change theory. So, for instance, are you going to have to show that a government employee, oftentimes in this kind of situation, contracting officer, because that's the person's knowledge that's really important, are you going to have to show that that person is a liar? And if so, that's going to be probably something that factors into your business decision. You'll also want to discuss how, based on your relationship with your government customer, the REA might be received. Many times, most contracting officers have received many requests for equitable adjustment or claims throughout their career. They don't take them personally, and depending on the relationship you have with them, they probably will even know it's coming. And as your program folks have been talking, hopefully, with the government side, they have an idea, or they should have an idea, that an REA is a possibility. And with that in mind, that's sometimes a factor that often sways the business decision of, they've known this was a possibility, we really have to go forward with this, or we're going to either lose X amount of money, or we're going to have a bad past performance rating, so we have to do this. But ultimately, it is a discussion that has to happen with the business team. And so really quickly, before we finish up with some of the last nuts and bolts of what goes into an REA, we wanted to ask you all if you have ever submitted or received an REA before. So if you're on the contractor side, have you submitted one, or has anyone at your company? And if you're on the government side, have you ever submitted or received one? So we'll take just a few seconds to let you guys answer that question.
It's about half and half.
Yeah. So it looks like about half of you may have done them and half may have not. And so hopefully those folks who've submitted or received an REA before still find these next few slides useful, or maybe you'll have some questions. Do feel free to put those in the Q&A widget at the bottom. So one of the things then that often comes up during that discussion on the business side is whether or not you should submit an REA or a claim. And really, there's probably 4 factors that end up weighing on the company decision makers in this situation. It's the purpose of the document. Why are you wanting to submit something to the government in the first place? Are you trying to negotiate, or are you trying to position yourself for litigation? And that's probably going to be, that factor is probably going to fall based on the discussions you previously had with the contracting officer. The second type of consideration that will probably come into play is timing. The contracting officer has plenty of time or can take his or her time in responding to an REA, but has a statutory deadline to respond to a claim. Sometimes they don't meet that, but there is a statutory deadline there. The third factor that will weigh for the business decision is the cost for preparing the document. Jeff mentioned earlier that the preparation costs are allowable for REAs. They're not allowable for preparing the claim, so sometimes companies let that factor in. And number 4 is interest. So interest starts to accrue on a claim once the contracting officer receives it, and so that means there is no interest on REAs.
And let me just make one point as Jana turns the slide, and that is, as we said, the costs of compiling or preparing an REA are allowable. Those are reasonable costs. This is not a full lawyer employment program or consultant employment program. The costs have to be reasonable, and generally they are. But I just want to sort of qualify what I said earlier, just to be clear. Sorry, Jim.
Yeah, no worries. So once you've decided to go forward with an REA, of course, I think the next question is, well, what do we put in it? And this slide has, I think, really the three big bullet points. The first 3 big bullet points are the main things that you see in an REA. The facts, which should be dispassionate and unemotional, but also should be backed up with evidence and referenced in the REA, even if you don't include them as attachments. The second thing it typically has are legal arguments, and that gets to part of why you're doing the legal analysis previously. And then the final thing is the basis for your equitable adjustment, or the amount of your equitable adjustment, or the calculation you have in there. The government needs to know if you're trying to claim, or if you're requesting that the government adjust the contract by $3 million, they want to know why you think you're entitled to $3 million. And so that's the third thing you'd really have there. And if it is an REA submitted to the Department of Defense and it's over the simplified acquisition threshold, there'd be a certificate as well. So a couple of other things you can consider putting in your REA. The first and the last bullet point here are really just things that will help make sure you don't give up the opportunity to get preparation costs, and also can help eliminate issues down the line. Because if you have a statement that the intent is to resolve via negotiation, that helps to show that this is truly an REA and it's not a claim. And so then you're just helping yourself avoid issues down the line. The second issue gets to the litigation hold notice that Jeff was mentioning earlier. Usually now in the REA, we do include that. We found it to be very helpful, and I think a good example recently is there was a situation where a contracting officer was leaving her agency in between the time of our submission of an REA and a claim, and it was really important then the contracting officer keep all of the emails that were applicable, and it was really important because the series involved some of her knowledge at the time the contract was awarded. And so these last 2 slides are the final nuts and bolts for the REA, and it's who do you submit it to? It goes to the contracting officer. It doesn't go to the contracting officer's representative or the technical representative. You can copy them if that's important for your relationship with them, but this is a decision that has to be made by the CO, so you're going to submit it to the CO. And then what's the CO going to do when they get it? They may ignore it, which does happen. Or if they come to a decision on it, whether it be to deny it or to move forward with it potentially, they're going to do that after consulting with their program team and advisors. And almost always that is going to include getting the advice of their legal team. And that's really why we encourage contractors to put a legal analysis in their REA. The legal team is who you are really trying to persuade by this document. You've already tried to persuade the program team and the contracts team through your day-to-day discussions, and that's failed. This is the first time, probably, that the legal department has gotten involved, and that is who you are trying to persuade, because those attorneys they'll talk to the contracting officer, but they also may be able to go over the contracting officer's head and push their advice from higher up down to the contracting officer. And oftentimes in that situation, the CO will request further information, oftentimes about the amount you're requesting. And finally, Jeff mentioned earlier some of the ways to continue on if an REA is denied or ignored. He's mentioned the Court of Federal Claims and the Boards of Contract Appeals, and that's where you would go after you've converted something to a claim and it's been denied or deemed denied. And you'd have to convert it to a claim first because there is no immediate remedy for denial for an REA.
As Jada is pulling up to see if there are any questions to us, let me just say the takeaway slide is in front of you. Much of it is summary of what we talked about. Let me focus on 2 points here. One is read the contract. I think whatever program that I end up doing, I know Jana and our colleagues do, this is always sort of top of the list, read the contract. If people read the contract, we wouldn't be all that busy, Jana and myself. A lot of times, people don't know what's in the contract, but you should know what your changes clause are. And changes clause is in the contract and what your obligations are surrounding that. And the other piece is there's some timely written notices to the CO and then timeliness obligations that follow from that. I think it's important that you're very familiar with that, or your program or legal teams are very familiar with that, so you don't miss a deadline. Because if you miss a deadline, you don't get much sympathy from the government, or for that matter, the courts. I really want to thank everyone for participating. But Jane, do you have any final comments on the takeaways?
I think really just for me, the last two, in part just because I think I've dealt with these kind of issues lately, of where the contractor could have really benefited by tracking information earlier on, and I think it could have helped them into the negotiations a lot earlier if they'd had more information to support their calculation. And I think also it's really important when you're drafting the REA to have the advisors in mind. You're not just drafting this for the program people who you've already been talking to, you're writing it for the attorneys. So if you guys have any other questions, let us know. Otherwise, you can let us know what is one thing you learned today just by answering it in the Q&A widget. And you'll also be able to complete an evaluation through the other widget at the bottom.
And we are just about an hour's time. If we get any other questions that we have not answered already within the scope of our discussion today, we'll send out an email. But we really, as I said, appreciate everyone's time today. I know everyone's busy with their schedules. Jana and I had a mission today. Our job was to talk, your job was to listen, and hopefully you didn't get finished before us. So thank you very much for your time and effort today. And if you have any other questions, do not hesitate to follow up with us. Thank you.